Thanks to everyone. Good morning. And Representative Maury, you want to go ahead and start with your meeting goals for this particular meeting?
Thank you very much. And this being September 11th, if you don't, we would just take a brief moment of silence in honor of what happened 19 years ago that forever changed our country and our world, and just have a brief moment of silence. Thank you. It's hard to believe it was 19 years ago. Okay, we have, I think, a great agenda. We have some wonderful speakers, and today we're looking at pretrial and bail. It's a fairly wide-ranging topics, but we have three experts from across the state that have implemented some terrific pretrial services and how it does impact bail. And of course, the bottom line, how does this impact racial inequities in the criminal justice system? So we will get to them in just a minute. It'll probably be a full discussion the rest of this meeting, and then we'll talk about the future meeting where we can absorb it and hopefully come up with some recommendations to the full task force based on what we have learned. If we are missing any issues or other people you think would be important, we perhaps could continue this to the next meeting next Wednesday, if that's helpful. Sound good? Anyone have any questions, concerns, issues before we start and hear from our presenters? Okay, we're ready to roll. Karen, would you like to, do you have the agenda? Would you like to go ahead and do the introduction?
All righty then. Well, we have our first presentation. Welcome to Sonia Harper, who is the director of Mecklenburg County's Criminal Justice Services Department. And so we're going to go ahead and start with her. If we have an opportunity, maybe we can take a couple of questions after her presentation, but we're going to try to save the bulk of the discussion, I believe, for when we can talk about the presentations in total. But if there's some burning things that you would like to ask after her presentation, the presentation of our other two speakers, please do so. So again, a welcome to Sonia Harper.
Thank you. And thanks again for the invitation. I really appreciate the opportunity to speak with you all and to share with you, some of the things that are happening in Mecklenburg County with our pretrial services unit. So I had some presentation slides that I had prepared. I don't know if you've got those. If not, that's fine. I can kind of just talk through. So I guess just to kind of, to really kind of start off, I'm having some technical issues here, of course. Sorry. Oh my, here we go. So really it's just to really, to start off, one of the things whenever, we're looking at pretrial services, in our jurisdiction, and really we started conversations about ways to really sort of improve and retool our existing system really over 10 years ago. And as our conversations have evolved over that time, one of the things that we have really looked to integrate into our system is disparities and disproportionalities at different touch points within our local criminal justice system, and that includes the pretrial phase. And so we did some early, really started a couple of years ago, really kind of looking at disproportionalities, particularly at the booking phase within our system, so that we could really understand the, where disparities were occurring and the extent of those disparities. And so when we were looking at disproportionalities at booking, what we were finding is that, really for every 1,000 people within our Mecklenburg County population over the age of 16, our jail booking rate was roughly about 13 for white residents in Mecklenburg, but we're over 54 for every Black resident in Mecklenburg. And so, we definitely recognized that, that was an issue. And so as we were retooling the things that we had going on within pretrial services, we definitely wanted to take that in consideration. And so when it comes to racial and ethnic disparities, we do have a separate body of work within our jurisdiction that really is looking at ways that we can impact practice and policy within the jurisdiction, related to RED. So, really kind of associated, now that we kind of understand, who is in our system, we wanted to really understand, how they were being impacted, at the pretrial phase. And so, we, took a look at the literature that was out there and did this really kind of research review. And so, sort of the general overview of pretrial research shows us that detained individuals are more likely to be convicted. When we look at, incarceration, we find that folks that are detained are over 4 times more likely to be sentenced to jail and over 3 times more likely to be sentenced to prison. And then when we look at even further into incarceration, we also find that detained defendants are nearly 3 times are also detained, or their jail sentences also tend to be 3 times as long, and prison sentences tend to be twice as long. And so, the research also, we took a little further dive into the research because we wanted to also understand recidivism as it relates to the pretrial population. And so the research also tells us that, for those low risk offenders, folks that are in custody, there is a significant impact on recidivism rates. And so, for low risk folks that are held even 2 to 3 days, research finds that those folks are more than 40% more likely to commit new crimes. And when we look at recidivism over a longer period of time, even those low risk offenders that are held between 18 and 14 days are almost 51% more likely to commit another crime within 2 years after completion of their case. And so, the research really kind of, again, as we were looking into these things and looking at how it is that we could, refine our system. And, we also were very cognizant of the fact of, the role that money plays into, into our system. And, we had done some very kind of intensive look at our data, in years prior that also led us to, to have a better understanding of the fact that we had historically had a lot of folks in custody that were there simply because they could not post bond. And so that really kind of sparked us into, some conversation about, our pretrial system there in Mecklenburg of really kind of moving away from a charge-based system and really looking at risk. And this also aligns with, those pretrial best practices that are out there. And so, we had, lots of conversation with key stakeholders about bringing a real systemic shift, to our processes. And again, looking at, risk as opposed to the charge. And we wanted to do this for, a number of reasons. I think, first and foremost, we felt it was really the move to make to better ensure the public safety. We also, again, with, our focus on RED and some of our other work, we also wanted to develop a system to where we were being as objective as we possibly could in our decision making, and also kind of reduce the opportunity for any bias to be introduced into that decision making process. We also were very interested in upholding, the state statute that, that indicates that the least restrictive means should be utilized in the pretrial phase. And so we kind of, continued on with these conversations and really started, to better define what the role of pretrial services is in Mecklenburg County. And really where we landed is, our role for pretrial is to measure risk and then to manage risk. And you will find, that also is consistent with a lot of the pretrial literature and research that's out there. And so, when we talk about best practice and talk about risk within pretrial, one of those things that is highly recommended is the utilization of a risk assessment tool. And there are lots of different tools that are out there. Some tools are better than others, well, just like with a lot of things. But for us, we definitely wanted to have something in place that was able to, again, help us measure risk and then provide information that would be helpful to our judicial officials in their decision making. And so we had used a tool prior to 2014, a tool, the Virginia model. And in 2014, we moved to utilizing the public safety assessment. And, we made that change because we felt, again, it was much better aligned with, our goal of having this risk-based system. It was a very well-researched, very large data set that was pulled together when that tool was developed. And one of the things that we also liked about it is that it didn't require a face-to-face interview. And, and sometimes, not having that interview, can sometimes make, folks a little nervous. But for us, when we were really kind of stepping back and looking at process, again, keeping in mind one of our goals was really, not to have opportunities for bias to be introduced into the process, and also to be as objective as possible. We felt, not having that interview piece there would actually be helpful in us helping to achieve that. And so we've moved along, and I'm having some technical issues again. And so we've moved along, and when we were looking at the risk factors also that the PSA measured, that also fell in line with what we were looking to do. So we really just wanted, to have the things there that are really kind of geared towards, again, assessing a person's risk to public safety, and then also what's their, the likelihood that they're going to appear for court. And so, we're looking at really just the criminal history. And when we look at criminal history, we're really looking more at convictions and not so much arrest or just simply charges. And so, another kind of recommended best practice is just, when you have whatever risk assessment tool you land with, it's always important to have, a validation in place, a validation study. You want to make sure that the tool is working the way in which it's intended. And then you also want to make sure that, you're utilizing the tool properly within your jurisdiction. And so within Mecklenburg, we've had 2 validation studies completed since 2014. Our most recent, we wrapped up the analysis at the end of 2017, and the report was published in early 18. And whenever we found those results, when we got those results, we were really surprised by some of those findings. Because as we were sort of moving along and developing this system, we were pretty conservative on our release detained decision making. We were, really, definitely concerned with the role of money and who we had at our jail. But what we were finding is that when we completed this most recent validation, even those folks that we've typically had in sort of a high risk bucket, those that were scoring high on our PSA, when we took a look at failure to appear rates and new criminal activity rates, what we were finding is those folks, even high risk, were compliant. They were being successful. And so even with our failure to appear rates, for our folks that are low level, those that have low risk scores, we were finding roughly, 88% of them were showing for court. But even those on the high end, the highest end of the scale, over 60% of them were showing for their court dates. We found, kind of similar things with new criminal activity. Those on the low end, over 90% of those were not committing new offenses while they were out pretrial. And even our high risk folks, we were still finding roughly 50% of them were not committing any new criminal activity while they were being released. And the same was really found for those that even had violent histories, for those that had, convictions of violent related charges on their records. We were finding really the same thing. Those folks were still being successful while they were out on pretrial release. And so, attached to this too, and also kind of tied to our red work, we also had some interest in wanting to know if there was any sort of, if the PSA was having any sort of impact on disparities. And so we had done, some really kind of more high level examination of that within the PSA validation. We also conducted, had a research partner that we connected with in 2018, 2019, to really kind of take a deeper dive into the role of our PSA, the risk assessment tool, and disparities within our jurisdiction. And really what we found, particularly with the PSA, is after its implementation, our bail setting was lower than predicted after the PSA policies were implemented. And we found that effect to be similar amongst both Black and white defendants of the same assessed risk levels. The studies also showed us that our rate of initial detention were lower than predicted after the PSA policies were implemented. And the effects on initial detention in jail were similar for Black and white defendants. But when we kind of step back and look at that overall, what we did find is that, what the conclusion was is that the PSA policy didn't have any effect on racial disparity in jail detention. So when we took all that information, what we found was, and we never had any intention of like the PSA or the risk assessment tool being, the response to disparities in our system. But what we took from that is that, okay, the changes that we've made in this introduction of this tool is not contributing. It's not making things worse. And that also put us at a position to where, okay, there are other things that are happening at the jail booking touch point that we need to examine in order to have, impact on disparities at that point in our justice system. And so we have, again, attached to our red work, another body of work that's looking into that area. So as we, have these results from the validation, as we've, taken a look at all these our different processes, we really started to have conversation about who we're releasing from our jail, and the need to be much more intentional about making release detain decisions. And so we really started taking again those results and taking a look at developing a release conditions matrix for our jurisdiction. And basically this serves as a guide for our judicial officials whenever they got someone before them for first appearance and are making a decision as to whether to release or detain that person. And so I think it's important, to stress that, this matrix and these recommendations are simply just that. They're recommendations. We still have that expectation of our judicial officials to be examining all elements of the case whenever they're making that decision to release or detain. This does not take away from their discretion at all. So we kind of view this as being, a tool in the toolbox. But as we got into, into the development of this, we spent roughly about a year with the leadership, the other criminal justice leaders within Mecklenburg County, to have discussion about, exactly what this looks like and what this would mean for our system. And where we landed with our new release condition matrix is if the decision was made to release, there was no bond attached to that. And so what this did was actually made pretrial release, pretrial supervision available to a much greater number of folks within our jurisdiction. And again, kind of going back to what we found as we did our validation studies, is even those folks that are scoring the highest on our, our risk assessment tool, for the most part, the vast majority of those folks are, being successful. And so it put us at a level of comfort to where, again, we could open up the pretrial option to a greater number of folks. At the same time, when we had these validation results and we started having these conversations about pretrial release and changes there, we also started having conversation about bail policy and what our bail policy is in Mecklenburg County. And so at the same time we were having these conversations about, release conditions matrix, we were also having this simultaneous conversation about bail policy. And those conversations came about for, a lot of reasons. I mean, part of it was our findings and, our experiences there within our jurisdiction. We had been following very closely a lot of the national legal and evidence-based conversations that were happening. And that included, the lawsuits that were occurring across the country that, the ACLU and the Civil Rights Corps had been filing. And of course, we know the first of those was filed here in North Carolina in Alamance County this past fall. And so we were also kind of paying attention to that and what, some of those recommendations were. And then, of course, there had also the North Carolina Commission on the Administration of Law and Justice had also had recommendations for pretrial, which we were taking into consideration. And so as a result of that, we implemented a new bail policy in March of 2019. And in addition to the new, release conditions for pretrial, I think the other thing that's really important about our policy, or that's significant about our policy, is that we removed the monetary bail schedules from the Mecklenburg County bail policy. So I think, just kind of kind of wrapping up here, we have jurisdictions that reach out to us all the time, with questions about pretrial and how to do it. And those jurisdictions are sometimes those that are new and are starting up. And then some of them are, jurisdictions that have existing pretrial programs and are looking for ways to retool. And so I think, kind of moving into this work, I think it's very important to ask, some key questions. And these were questions that we asked ourselves kind of early on in our process. And the first of that is like, who is in your jail? Really kind of taking a look, do you have folks in there that are sentenced offenders, or are they simply, pending trial? And also asking, why are they there? Are you utilizing your jail to hold violent offenders, or do you have folks that are simply stuck there because they can't afford to post bond? Who are you releasing? And who are they releasing? So what type of offenses do folks have? If you have a supervision piece to your pretrial program, I think it's important to look at, are you using those pretrial resources wisely? And then also really kind of taking a look at what the bond setting practices are. And I think this is kind of the piece where, there's involvement from counties or interest from counties. is because although the courts make pretrial release decisions, counties, we're the ones who really feel that impact in real dollars, and that's in jail bed savings. And I think, really kind of, an example I could give you with that is, we have within our jurisdiction, within our department, we have a jail population coordinator, and that person monitors who's in the jail daily. And, if we identify, someone there, if something doesn't look right, if it's a low level offense or a low level bond, that coordinator pulls together representatives from the public defender's office and the district attorney's office to really kind of engage in some conversation as to why that person is in custody. So for fiscal year 1920, our jail population coordinator facilitated the release of 770 individuals from the Mecklenburg County Jail. So when we kind of calculate out, if those folks had remained in jail until their court appearances, the release of those 770 people translates to 17,961 jail beds saved. And so when we translate that into dollars, and when we look at, our sheriff's office reports, it costs them roughly $145 per day to house an individual in our jail. So when we look at those 770 individuals, those 17,000, jail beds saved, that translates into a savings of roughly $2.6 million for the county. And so, I think those are definitely really important questions, to ask, as you're, moving into this space. And then I think, the other thing is really to be purposeful in your pretrial decision making. And that's been the thing that we have really been moving and challenging our judicial officials within Mecklenburg, is really, to ask yourself, who do you want to detain and who do you want to release? And then when it comes to setting bond, because of course we know, money is tied to the statute here in North Carolina. If you are, recognize that when you set every bond that you set will ultimately result in either detention or release.
Sonia, I'm gonna need to
yes.
to tie it up so that we can a couple of questions. All right.
That is that was the last thing I had there. So perfect timing.
All right, great. Thank you. And thank you for your presentation. And thank you for adding those statistics there, even at the end in terms of questions. So that was very good. Let me just entertain before we go to our next speaker. Is there anyone that has a pressing question for Sonia right now?
I'll jump in. Sonia, that was great information, a lot of information. Who is paying for Mecklenburg's pretrial? Is it everything's funded by the county?
So in Mecklenburg County, yes. Yes. So pretrial services is a unit of our Criminal Justice Services Department. So we are completely county funded.
And what resistance did you have, especially from the bail bondsmen, when these new policies, were they on board with the discussions, or how did that transpire?
So early on, so yes, so there was, input, particularly with the implementation of the PSA. We did have members from the bail bonds community that were there. And so initially, yes, there was, concern because, we're having this conversation about releasing a greater number of individuals. But overall, once we really kind of got into the conversation about, how it was we're looking to utilize our jail, because in Mecklenburg too, I think it's important to point out, our Board of County Commissioners does have an eligibility policy. So there are certain offenses that, we don't permit for pretrial supervision. And so when we got really kind of into the talk of like the dollar and cents of things, a lot of those cases that have those high bonds, the ones that bondsmen are making the most money off of, are the ones that wouldn't be eligible for pretrial supervision. And so when we really kind of got into the detail and having conversation about, who's there, the pushback wasn't that bad. And even as we moved into 2019 and implemented the new bail policy, which in fact still opened up, the opportunity for pretrial release to a greater number of individuals, we didn't have really a significant amount of pushback from the bond industry. We did have some pushback locally, though, from law enforcement. And so, there were some things that we had to kind of walk through and with that there. But from the bond industry, it hasn't been that bad for us, not in Mecklenburg.
Great. Thank you again. Thank you. So what we'd like to do is move now to a presentation by Caitlin Finnegan. Caitlin, did I pronounce your name correctly?
You did.
Alrighty then. Well, Caitlin is the director of the Orange County's Criminal Justice Resource Department. And so she's going to provide us with some more information. Thank you, Katie.
Good morning. It's such a pleasure to be here, such a privilege to be here, and I'm just so excited about the task force work. Can't wait to see all the recommendations coming up. I was going to share my screen, and that is not the shared screen that it should be. Huh, sorry. Same problem maybe Sonia was having. Let me just get to my screen. All right, hopefully this will come up. All right, can you all see the screen? Is it working?
Yes.
Okay, great. So I come to this a little bit differently than other pretrial programs. I'm actually have spent since 1994, I've been a criminal defense attorney, a public defender, a capital defender. And so in 2015, I became an administrator. I became the director of the Criminal Justice Resource Department that was started here in Orange County. And pretrial services was one of the programs that was put under my supervision. So I just say that because I think it does influence the way I look at pretrial, having had many clients who have been impacted by unjust pretrial policies. These are some of the things that Sonia actually talked about as well. This is national data from the Pretrial Justice Institute, but we know these inequities exist. We know that reliance on a money-based pretrial system is racially and economically biased. It automatically disadvantages people of color who, for systemic and structural reasons, are less likely to be able to afford money bond. We know African Americans are 66% and Latino individuals are 91% more likely to remain in jail pretrial than similarly situated white individuals. And compared to white men charged with the same crime and with the same criminal histories, African American men receive bail amounts 35% higher, Latino men receive bail amounts 19% higher. So this is national data, but it's, we know the problem is real. And as Sonia also touched on, we know how destabilizing pretrial detention can be, even if it's just for a couple days. The impacts that it has on a person's employment, their housing, their family, their health, and of course the likelihood of later recidivism. Data is clear that pretrial detention does increase the chances of recidivism. And again, Sonia mentioned the case outcomes. I know that from being a defense attorney. If my client was in custody, I knew that they were more likely to receive a sentence of incarceration. It's easier for a judge to give somebody an incarceratory sentence when they're already in jail when they're before them. They're 3 times more likely to receive a longer sentence. And most upsetting, they're also more likely to accept a plea when they're innocent because they need to get out. And I saw that time and time again, and it was a struggle. I wanted to support clients who wanted to regain their freedom and their lives, but I saw them taking pleas that I knew were in triable cases, and that's a real problem. When we started, pretrial had been under contract as a nonprofit with the county for years after state funding was lost. When I came on board in 2015, there were already a lot of good evidence-based best practices in place. However, there was no sort of oversight of the pretrial program, and there were a lot of things that our county knew we wanted to do. We knew we had additional reforms we needed to implement. We knew we wanted to reduce the inequities and disparities that we were seeing day in and day out. We knew we wanted to reduce explicit and implicit bias. We knew we wanted to think about implementing a risk assessment tool that would promote safety by looking at risk. We knew that our pretrial supervision and accountability needed to address needs and also look at enhancing court appearance rates. We knew we needed to look at the case management of people who were on pretrial supervision, making sure that justice-involved individuals were receiving services while they were awaiting trial. And we knew that we wanted to reduce our pretrial population, the cost to the county. And as Sonia mentioned in Mecklenburg, here's sort of a breakdown in Orange County of what it looked like when we assessed the daily cost per day per individual in our detention facility, $111 per day, not the $145 in Mecklenburg, but $111, which contrasts to less than $2 per day for a person under pretrial supervision in Orange County, and that would be $5.50 per day if they were on GPS monitoring. But for other types of pretrial supervision, it's only less than $2 a day. So a huge saving to the county. So pretrial reform in Orange County has, like I said, started a long time ago, but it really jump-started in the last few years. We, in 2016, created a Criminal Justice Resource Department, which, created a Criminal Justice Resource Department, I've already talked about that, but internalized our pretrial services in addition to a lot of other programs. And that sort of gave us an opportunity to really sit back and examine what would work for Orange County in terms of reforms, because there's not one reform that fits for every place. We had the benefit of county commissioners who were absolutely committed to reducing unnecessary pretrial incarceration. They really wanted to address disparities and address wealth-based detention. They passed a 3 days count resolution. They, of course, passed the Stepping Up initiative to reduce the number of people with mental illness and substance use disorders in our jail. So they were already fully committed to this work when I came on board. We have incredible stakeholder partnerships and communication in Orange County. Jim Woodall's here, I know. We have a Justice Advisory Council. We have a Racial Justice Task Force that he co-chairs. We have a pretrial work group. So we really have a lot of communication, and I think that's critical to moving the reform forward. We also have a pretty active community that cares deeply about these issues and has come to learn a lot more about these issues in the last few years. We have an active court watching group that comes, and they even put together a report last year based on their court watching, and it was eye-opening. They really pointed out the number of people of color they saw day in and day out at first appearances at the jail. And it was stark. So we really appreciate the advocacy from the community, and that helps move things forward as well. Can't thank Jessie Smith enough. She has been an incredible partner. We're actually under contract with her Criminal Justice Innovation Lab and have been working on some additional reforms, but she's been guiding us all along the way, and we're so grateful for that. Racial equity trainings have been a big part of the work we've done to move pretrial reform forward. All of the people, the 12 people in my office have all been to REI trainings, and most of our stakeholders have as well, and we've been attending national conferences. So I think that has really helped us along as well. You know, I came to the notion of a risk assessment tool with some trepidation. I've seen how risk assessment tools have been used against my clients in the past to assess a risk that I thought was unwarranted. But I and my pretrial case manager, Ted, really looked into whether this was going to help us in Orange County. Again, as Sonia said, not all tools are the same. There were a couple of evidence-based tools, the PSA and the Virginia Pretrial Risk Assessment tool that were recommended. We decided that we wanted to try it. We did a 90-day trial to compare outcomes from the risk assessment and what we were seeing currently at that time in court. And it was clear that the outcomes were better with using the tool. So we decided to implement the tool, but you know, I want to make sure that it's clear that there are the pros to using the tool. It's certainly helps guide discretion and enhances consistency. It does reduce subjectivity and implicit bias concerns. It focuses directly on what the statute requires, looking at, which is likelihood of returning to court and risk to the community. It helps pretrial determine the appropriate level of supervision. And it can be implemented with very little financial resources. But these tools have built-in bias, right? You know, these risk factors look at prior criminal justice involvement and convictions. And we know that people of color are over-policed. We know that they're overcharged, and we know they're subject to mass incarceration on a much greater scale than others. So that bias is embedded in these risk assessment tools, even the best ones. And so that's important to note. They also have not traditionally shown a lot of effectiveness in or value in predictability. So that's something that we need to keep looking at. They don't address the needs of clients, specific clients. They're not client-centered. They treat individuals like algorithms, and that's a concern. And most importantly, they don't consider the risk of incarceration. And there is a risk to incarceration. And that's something that I think is important to think about when courts are making, or magistrates are making decisions on release. We did decide to go ahead and use the revised version of the VPRE, and I'm just going to go through this quickly. You'll have this these slides you can look at more closely, but those are the risk factors, and then you get a score from that and a risk level. And then you get to this praxis where you look at the highest charge and apply the praxis, which then gets you back to a level of supervision that's recommended or no supervision. So here's what ultimately we put together when our pretrial case manager puts together every day for our first appearance court. It's a summary of the risk assessment tool. And you'll notice at the very bottom under recommendations, there's release without supervision. And that's really important because one of the things we don't want to do is put everybody on pretrial supervision if they don't need to be on pretrial supervision. So that was one of the things we were seeing when our judges started trying to keep people from going to the jail. They often just put people on pretrial supervision who didn't need to be. They didn't need any supervision at all. So that's important. And has been a huge improvement for us. We also add additional considerations there, and that's the difference for us. We are a smaller jurisdiction. We have fewer numbers of people obviously coming into our detention facility. We're able to do an in-person interview and look at some of those needs of people. And I think that is really helpful information for the courts to have when they're making a decision beyond just the sort of algorithm piece. So that's the assessing and addressing needs. That's really important to me. I like an in-person interview, even if it's somebody who may not be coming onto pretrial supervision, because they're in the jail, having not talked to anybody, about to face a judge at 2 o'clock. They need to know what's happening. Is there anybody that they need called who could be there at the court, who could be a support for them? We just like to have contact with everybody that's booked into the jail just to give them some basic information. And of course, for most of the people, that does involve a full intake interview. So that's important to me, and it's been an important component of our program. The case manager confirms mitigating and needs information. I think that really increases informed releases. For instance, if we were just doing the algorithm piece of the risk assessment, we would never know that this person in the last 2 years has been connected to a mental health provider who is providing weekly support to this person, and that person can be in court for them at 2 o'clock. I guarantee you that makes a difference to the judge, and might let a higher risk person be released if they knew that support system was there in the community. So that's important to us. And equally important is also that our case manager then refers people to behavioral health professionals. We have a licensed clinical social worker and a psychologist who works in our office who does follow-up referrals as needed for people both who remain in the jail, but also for people who were on pretrial supervision. So that I think is a critical piece beyond just a case manager. So just a little bit more about our program. We have one dedicated case manager who is Ted Dorsey. If any of you know him, he is highly experienced, highly respected, and just amazing. And he sees everybody who's booked into the jail. He verifies all the information, prepares the risk assessment summaries and recommendations prior to the court date. Our first appearances are held at 2 o'clock, Monday through Friday. We handle all cases come before our first appearance court that are booked in. That's misdemeanors, felonies, and even orders for arrest that have had a previous first appearance, but they need to know, their lawyer needs to know they're back in the jail, or their court date has now been reset. Our district attorney's office and public defender's office is present. Every offense is eligible for supervision with a court order. GPS monitoring is available, but it's only available for higher risk individuals. We don't want people being put on GPS monitoring if they don't need to be. That is a highly restrictive level of supervision that really should be reserved only for high risk individuals. So we try very hard to make sure that it is limited to that. There's no cost to individuals for pretrial supervision or GPS. We do a robust court date notification, AOC notification. We also have an automated system for check-ins and court date reminders. And our software does collect data, which is, as Sonia said, is such a critical piece to keep looking at our data and where we can improve. We've had just a tremendous increase in buy-in from our judges. I think judges like a risk assessment tool because it gives them something to support their decision. It increases transparency to the public as to why a decision was made. We did see our average daily population in pretrial bookings decrease from 2018 to 2019, and I think we're going to see it. We're still crunching the numbers for this last fiscal year, but I think it will be significantly we'll see another significant reduction. This is something Representative Morey first shared with me, was how to handle OFAs, first-time OFAs in court. They had a process in Durham where they were automatically letting people come in and get a new court date, no questions asked. So we started something here called our strike order hearings, and they're held weekly. And that's a critical piece because we were seeing people come in on OFAs or being brought over, from court because of OFAs, and they really didn't need to be in our jail. So our strike order hearings, everyone gets a one-time, no questions asked, new court date. And then for people who have maybe missed court more than that, we then get them interviewed by pretrial services before they appear in front of the judge so that we can hopefully still not have them come into our jail. We created a daily jail dashboard to create a snapshot of what every day in our jail looks like, with data about disaggregated by race, gender, charge, bond amount, so that all our stakeholders can see that. We have our magistrates referring directly to pretrial, so hopefully we don't even get that 1 or 2 days if it's a weekend, a person sitting in jail before they're released at first appearances. We have a wonderful new magistrate tool that is just being implemented now. I'd show it to you, but it's still being finalized by Jessie Smith and our stakeholders here, but that has already gone into use and has been wonderful. And a non-appearance flow chart is something else Jessie is doing for us, and that's for judges who have failures to appear. The standard operating procedure was just a small cash bond on misdemeanor cases for a failure to appear. And it doesn't need to be. The magistrate, when that comes in with a $200 cash bond, cannot change it. So we are creating a flow chart for judges to look at setting a new court date, having an OFA with a written promise, letting the magistrate have discretion, that kind of thing. So I'm hoping that that's really going to be beneficial. And I think Jim Woodall talked about this at a prior session of the work group, but we really need to shrink the funnel of who's coming in, right? And so increasing the use of citations by law enforcement, using pre-arrest deflection programs. We have OC-PAD, which is for first offenders, where officers just deflect them completely to one of our social workers. And most exciting, we have a new program called the Street Outreach and Harm Reduction Program, and that's for the people we used to see coming into our jail constantly that are experiencing homelessness, that have behavioral health issues, who literally come in and out, time served of our jail. We've got 2 peer support specialists and a clinical social worker who are going to man this program, and they're going to be embedded in the community as the responders to some of these incidents that law enforcement had previously been called to. So I'm really excited to see how that turns out. And of course, decriminalization of ordinances and low-level offenses is another area that I think will really assist us in our pretrial reform. COVID-19 has created some urgent measures that we've put into place. course, these should have been urgent measures before, but there's nothing like COVID to change how things are done. And I think things that we've put in place, like having judges on call for even domestic violence cases and failures to appear, having them on call 24 hours for the magistrate so a person doesn't have to spend that 48 hours if they don't need to, have really altered things. And I'm hoping that these are things that will be with us even post-COVID. I'm going to leave you just sort of here with a snapshot from our dashboard. This is from just this week. The wonderful thing about this is that our pretrial population is 29. I mean, it's never been lower than that. It's 29 people in our jail. But if you look at pretrial population by race, what you'll see is that 56% of the population of our jail is African American. Our population in Orange County of African American population is 12%. So the disparities remain. And that is something that we absolutely have to keep working on. And that includes, as Sonia said, a lot of work that needs to be done prior to a case even getting to the magistrate's office. But we can reduce our numbers of people coming into our jail, but if we're not reducing the disparities, then we've still got a lot of work to do. So I'm going to leave you with a very gratuitous picture of our courthouse facility dog, Adele, who we're so proud of. And I know Representative Morey is a fan of labs, so I just put that in there for a final slide. Thank you all so much.
Thank you, Caitlin. Thank you very much. Does anyone have a question that they really want to ask Caitlin right now before we move on?
Okay.
Caitlin, thank you. Oh,
That was fabulous, as always. What needs do you have? Like, if you could expand in a perfect world, where would you like to go?
It's mental health and substance use treatment. I mean, those are the two, and housing. I think obviously homelessness creates instability and certainly leads to a lot of low-level offenses. But the substance use treatment, and I know in Orange County, we have more than most places in the state. I mean, we do have a residential program, we do have outpatient treatment, but that's a real critical need, as is transportation to court, childcare, things like that, I think people miss court for a lot of other reasons. In fact, the majority of the time, I think it's because of, inability to, having to work a job or not being able to get childcare. So things like that would make a huge difference, resources.
all right. Thank you again. All righty then. Our third presentation is Christy Law.
Karen, real quick, if I have a
Yes,
quick question
please.
for Caitlin. Caitlin, real quick, as far as those risk assessments, I know they don't take account issues like childcare or lack of transportation, for example. Would those be things that you would recommend that we begin to include about why this person may have missed court?
Yeah, absolutely. I mean, I think we do include that in the additional factors. If it's coming off an OFA, we will, if there's any kind of reason why the person says they missed court, we'll include that. But one of the things that is also important is to study your district. And we're doing a academic study with some Duke researchers who are interviewing people in our jail on OFAs and people in court and at our strike order hearings to find out what is contributing to missing court. Is it childcare? Is it transportation? And so therefore, when we get that final study out, we'll be going to the county commissioners to say, these are where we need to dedicate some resources. But we know that court reminders are probably the best way to get people to court. But we know sometimes transportation and childcare are barriers. But yeah, you have to study that, find out what your barriers are where you are.
I believe in Mecklenburg County, we've begun, and maybe Sonia can speak to it, to send out letters to folks with court reminders. Do you all do that as well in Orange, or make phone calls at all, or?
So everybody that our case manager sees at booking, which he signs up, whether they get on pretrial release or not, they get signed up for the court automated AOC court reminders.
Okay.
And then anybody on pretrial gets an additional level of call twice, a week before and then a day before. And then in our courthouse, for people who are not on, pretrial supervision, they're given information there by our clerks as well. So we're trying to make it as robust as possible.
Thank you, Caitlin. Appreciate it.
Sure.
All righty then. Christy Long, pretrial program supervisor for Durham County Pretrial Services. Christy,
Good morning.
good morning.
So in an effort to not repeat all of the wonderful things that Sonia presented, as well as Caitlin, about the national data and the disparities overall regarding the pretrial program, I'm kind of going to just kind of skip to where we are here with Durham County. We've had a pretrial program here in Durham County since 2006. In 2011, we started using the Virginia model for a pretrial risk assessment to address the needs of the defendants that we had at first appearance. At that time, we went with the Virginia model so that we could have a form to recommend defendants for release. However, our version of that was not fully accepted the way that the model was intended. So it still allowed our pretrial specialists to make recommendations regarding release or not onto pretrial supervision. And we were also handwriting records at the time, and we had eligibility criteria. So over the years, we had concerns about some people being interviewed, some people not being interviewed, people being considered for supervision, not being considered for supervision, some being detained a little longer than others. So over the years, as those concerns came in, we went through the data and we decided in 2018 to address first appearance as a whole. We had a advisory committee meet and discuss the concerns that we had, and we discussed the magistrate level. We discussed the officers in the field, the format of the assessment that we were using, and supervision levels. So what we agreed upon was to also use what Mecklenburg County is using, which is the public safety assessment. And we've gone from the eligibility criteria to actually interviewing all of the defendants, providing a public safety assessment for all of the defendants that are present at first appearance instead of just the ones that are charge eligible. And we also are still incorporating the interview, although that is not part of the model for the public safety assessment. And the reason for that is because the judges still wanted to have available in the courtroom information about the defendant's community ties, their substance use history, any medical concerns, any mental health concerns or connections that were either broken or needed to be made for the defendants that we had at first appearance. So what we did was we expanded our hours of operation from 8 to 5 to 8:30 to 8 o'clock at night, Monday through Thursday. And then on Sundays, we have a team member that works from 8 to 5 so that we can reach some of those individuals in the community to verify the information before first appearance. We are not fortunate enough to have first appearance in the afternoon at 2 p.m. So we have to have it ready by 10:30 in the morning. So we have to work a little bit harder in the afternoon, a little faster in the morning to get things prepared for first appearance. But overall, we get it done. With respect to the magistrates level, we did have a meeting with them to discuss their ability to refer pretrial services cases to us from that level. Now, the majority of the cases that come through the magistrate's office, if they're eligible for either release on written promise or unsecured bond, they by all means do that. And if it's not appropriate for a written promise or unsecured bond, if they feel like the person is younger and they may need a little bit of assistance with getting back and forth to court, or may need to be connected to services, then they'll include us at that juncture so that we can kind of assist them through the process. And it's usually some of the younger offenders that may not have qualified for the misdemeanor diversion program, or they weren't able to get in contact with a family member at the time of processing in the magistrate's office. So they just want to make sure that they have a little bit of assistance to kind of get through that. As far as from the law enforcement we met the DA's, I scheduled a meeting for the DA's office to meet with the command staff with the Sheriff's Department and the Police Department. And they had a really good conversation about citations, summons, and arrest to address, you know, the processes and, you know, encouraging more citations and just some of the things that could be reviewed before they actually get to the magistrate's office, and including the diversions. So here in Durham County, we also have a misdemeanor diversion program. And with the misdemeanor diversion program, as you all know, now individuals that are 18 and over can be referred if they're first-time offenders. And we have a coordinator here that works very closely with them to make sure that they get referred to services. And they're also participating in the community service and the mock trials and all of those wonderful things that are incorporated in the misdemeanor diversion program. Now, with our cases that we have there, about 75% of those people that are participating in that program are African American. So with the referrals that they've had thus far, I'm sorry, I'm looking at a few different papers. We've got about, 50% of the people for the misdemeanor diversion program are African American, and then about 25 are Caucasian or white, and then about 15% of them are Hispanic or Latino. And the success rate for the misdemeanor program has been great thus far with the people that have been able to come through. And of course, the ones that were not successful will refer back to law enforcement for them to come through the court system at that point, if it was deemed necessary. So as far as first appearance is concerned, since all of the people now are receiving a public safety assessment, the court is now looking at the criminal history to make decisions regarding who is appropriate for release, and not just looking at who we recommend for release for supervision based on who we were able to reach and who we weren't able to reach. So everyone has the same information that's available, which is a full criminal history and the assessment based on their criminal history alone. And if they're available and willing to participate, we provide information regarding their interview. What we also did was adjusted the levels of supervision. Before, our supervision levels were kind of based on whoever was on the bench, and they kind of varied, you know, based on charges or what have you. Now our public safety assessment addresses the supervision levels, and they are set according to the criminal history. So that information is presented for all of the defendants at first appearance, and it follows their court file from then until disposition. So they do have it available in the court record. The majority of the cases that we get at first appearance are sent to us with no bond attached, well, no required secured bond attached. The bonds are usually unsecured. We do offer electronic monitoring at first appearance for those individuals that can be either GPS, curfew, or house arrest, but it just kind of depends on the circumstances regarding the charge itself, which kind of dictates the level of electronic monitoring. Our higher level offenders do receive also a public safety assessment at first appearance, but normally those people are not released to us unless there are extenuating circumstances. So that really doesn't really have a whole lot to do with race. It's just basically on the charge. Those offenders, however, are referred to us later on in the process if the court deems that they're appropriate. So we can do a little bit more of a deeper dive to address their appropriateness for supervision. So at that point, we do a little bit more investigation regarding stability factors and mental health compliance, and kind of set up some things in place to make sure that in the event that they are released, we're able to monitor them a little bit better. Now, as far as admissions are concerned for pretrial supervision, our admissions onto pretrial supervision have averaged around 400 for the last 5 years for the calendar year. And about 80% of the people that we supervise on pretrial supervision are African American. We've got about 14% that are white, and then another 7 or 8 or so that are Hispanic or Latino. And it's kind of reflective of our jail population, because for the bookings over the last 5 years, about 75% of the people that have been processed through the Durham County Jail have been African American, and about 25% of them have been white. Our average length of stay for the defendants that are not able to post bond or not released, it's usually 2 to 3 days. So they are released fairly quickly, but we do understand that there are some destabilization issues or concerns that, are still present for those defendants that are not released right away. But we do have a great mental health staff there as well that works with the defendants that's in custody to either do evaluations, or they're seen by the doctor that's present there for the hours, for certain office hours there to write medications, and the medical staff is also available. As far as our bail policy was addressed earlier this year. They didn't really make a whole lot of changes with the pretrial supervision. That was kind of left, I don't want to say separate, but the magistrate's office has their specific instructions that were set for them. But with respect to pretrial, I think it's kind of on an individual basis with respect to whether or not the defendant is released on a secure bond or unsecured bond. We are not restricted to charge types for supervision. So the defendants that we have on could range from misdemeanor charges to higher level violent offenses. So they do take into consideration flight risk and things of that nature when they're addressing the bonds. But the majority of the people that we have released to us do have unsecured bonds, are considered indigent, and are available for court-appointed counsel. And we do not charge for electronic monitoring. So if that is part of their conditions, then they can be supervised and we can monitor them from the time that their cases are started until disposition, or until the court deems them no longer necessary for the additional supervision. Now we average about, now since COVID, about 80 people on electronic monitoring. And just like they mentioned before, the higher level offenders actually do fairly well on supervision. It's the ones that have the lower level offenses that are usually more of a, wouldn't necessarily say problem, but they are a little bit more to handle because they don't face the same severity of consequences in the event that they are returned to custody. So we do have, we have had to make some significant changes with respect to our order of business since COVID hit. We actually started a soft start with our PSA in February. And then in March, around March 9th or 10th, we had a malware attack. So in the midst of us starting our PSA and our new process and just getting the team conditioned to doing it, and the jail using it, or excuse me, the court system using it, our system was completely wiped out. And when I say wiped out, it was wiped out to the point where we had to go all the way manual. We weren't able to use the application that we had created for this. So for a few months, we literally were in here day to day preparing information. However, it did not impact the ability for us to provide the information to court because we were still doing the interviews. Now with COVID hitting, our average daily population at the jail was about 400 this time last year. Up until February, it was about 400. Around April, our average daily population had been reduced from 400 at the jail to about 250. And it has maintained that since then. And that was basically the result of the DA's office and law enforcement and the public defender's office having a very serious talk about the defendants that were being processed at the jail and the citations, and then the defendants that were being released from custody for the ones that did not necessarily need to be there, so that they could allow for some expansion or better utilization of the space within the jail. So our dockets at first appearance have significantly reduced. I would say in 2015, the total of arrests at the jail was around 11,000. For calendar year 2019, we had right around 10,000. From February to August, the total bookings were around 3,500, between 3,500 and 4,000 people. That's a significant drop. So they've definitely taken an effort to look at the people that are appropriate for being in custody, which has helped with addressing some of the disparity for the people that are in custody. The ones that are there are really ones that may need to be there or have more serious issues to address, as opposed to the lower level offenders that can report to court. We also have court date reminders. So the defendants are offered the ability to sign up for court date reminders at the magistrate's office, at first appearance, at the jail for first appearance, as well as first appearance in court. And it's not just for the defendants. The victims and the attorneys as well can sign up so they can receive notifications. And so far, we've had over 11,000 people sign up for it. We're doing WebEx court. So if we're in the middle of court and they have failure to appear, if they haven't already signed up for it, we do recommend it. And we'll sign them up right away, right in the middle of court, so that there's no question as to whether or not it's done. And we try our best here in Durham to address whatever cases they send to us. So with any situations that come up, we try to make ourselves available and amendable to the request of the court.
Chrissy, thank you so much for your presentation, for your information. Any questions for Chrissy?
Christy, thank you. How many are on staff now with pretrial services at CJRC and Durham?
So for pretrial services, we have an office assistant. We have 3 pretrial specialists that are certified. We have 2 pretrial assistants, 1 full-time and 1 part-time. And we have a part-time position that is pending. We have someone that has officially been offered the position, but she hasn't started yet. So we're just trying to work that out. So on staff right now, we have 7, including myself.
Okay, thanks. And this is all dependent on the county commissioners approving the budget. I mean, everything for them. And I noticed you talked about victim notification. Is there victim outreach when you're doing the assessments or any of, the information of the judge? Does pretrial reach out to victims at all?
We do. So we reach out to the victims during second shift during interviews. If we're not able to reach them in the afternoons or in the morning before court. Since we're doing WebEx court, the pretrial specialist is actually in their office, and we are using the computers to access, the rest of the court system. So we're calling victims from in the middle of court to verify the information live so that we can relay that to the court. So because our dockets have been so much smaller, it has allowed us the opportunity to be a little bit more personable when it comes to addressing that with court. So we're able to have that information readily available, and the judges seem to really appreciate that, the ability to be able to do that right away.
And I'm sorry, I just had one follow-up. Does pretrial services in Durham do anything about physically going to the homes of people you're supervising? I mean, not like a probation officer, but is there face-to-face contact outside of the facility, or it's pretty much the staff stays at CJRC and it's all done remotely?
So right now, because we're in kind of a COVID protocol, we're not doing home visits as often as we would before. However, we do have a verification process for those defendants that are being referred to us, those higher level offenders. We do try to make contact with them or with their family at home to verify their home situation, so that when the court receives the report, they understand that we've been to the residence, we spoke to the people that live there, we kind of understand the layout of who's going to be there during their time of supervision, as well as if we have someone that's not connecting with us the way that we need them to, if we're not able to reach them by phone, or our letters are returned, then we will go out to the residents and leave door knockers or something to notify them that they need to get in contact with our office. So we do that.
You can notify the DA or the court if there's non-compliance with pretrial.
Yes.
Thank you.
Now, our office did not, our implementation committee did not approve a violation response protocol, but they did allow us to do one internally in our office that we could use as a guide to kind of form our violations. But for the most part, we notify them of the non-compliance and go through the regular process for court.
All right, thank you again, Christy. So want to open this up for general discussion, as Representative Maury said at the very beginning, looking for, what information, what's on your mind right now around based on the information that was just shared by these three presenters, around potential recommendations that, that you were spurred by your thinking here or even your thinking before. So going to open it up to general discussion right now.
Well, I guess I can start. I think one of the things that I mentioned is at least the experience in Orange County. As Kate said, we had pretrial release here for many years, going back over 20 years. And it worked, and it worked well at times, but we've had a complete change since our Criminal Justice Resource Office came in to existence. Everything is done so much more efficiently. I think we're reaching a lot more people. They're helping a lot more people. So I think one thing we should at least consider is a recommendation that all local governments at least study or consider creating similar departments for their county, because I do think it has to be done locally, and it has to be done on a county by county basis. And obviously some counties aren't going to have the resources, they're going to have other hurdles, but I think they should all be looking into this.
Thank you. Others, reactions?
I would like to, this is Ronnie Smith. I would like to say to all three presenters, I'm very much informed. There was great information, a lot of things I was not aware of, and I'm learning so much, of course, with the justice system. But I took a bunch of notes, and I know the first presenter did not have slides. I would love to receive those, some of those slides, and I can sit down and study them in the next couple of days. But overall, I just want to say to all the presenters, you did a great job and very educational for me. Thank you.
And I'll make sure everybody gets the materials.
Yeah, same thing. Thank you, Ronnie, for those comments. Appreciate all three of you presenting today. Wanted to ask if one of you know, like, do any of you know how much of the similar practices Durham, Orange, and Mecklenburg's doing across the state and some of the other counties? Are there a lot of different counties beginning to follow these models, or there's still a lot more work to do? Does anybody know?
I think there's actually multiple counties in North Carolina that have pretrial programs or are expanding. Buncombe County has done some really phenomenal work there with expanding their pretrial operations over the last few years. So they have, some really, I think some really exciting things that are happening there. Wake County also has had pretrial services in operation for quite some time. And so they have also been looking to make some adjustments and sort of retool some of the things that they've had in place. And so I think overall across North Carolina, there are, and I don't know if Kate or Christy have maybe more updated numbers on this, but I believe there's roughly about 30 jurisdictions across the state that have some element of pretrial services. And so that does look, very different in some places than others. I mean, Mecklenburg, we have very robust programming, but we're also an urban center. But yeah, there are roughly about 30 jurisdictions.
Yeah, and I would say I think the programs that have sort of the most robust reform efforts, aside from Wake County, do have either criminal justice resource departments or something similar. They're county internalized. New Hanover is another one that also is doing really good work on pretrial. And of course, then there's the Alamance County consent judgment, which now, imposes similar things to a pretrial release program without a pretrial release program by using IDS funding to make sure that there's, representation and intakes and ability to pay determinations, all of that. So there are ways that counties can explore this without having a pretrial program, but certainly having an internalized county one does make it easier.
Caitlin, in Orange County, do you all have public defenders present during first appearances?
We sure do.
Okay, great. So
That's critical. And so, and since in Alamance County, they don't have a public defender's office, that's where IDS has come in to pay for contract attorneys as part of the consent judgment after the lawsuit.
Yeah. Representative Moore, from my experience being here in Mecklenburg and being present during those first appearance documents, because the public defender's office is present just in general before we've been appointed. And that really helps a lot because we're looking at those PSA assessments as well. We're working with the prosecutors as well to see if anybody might have missed something to highlight to the judge in the courtroom at the time, which I believe helps a lot. So if more counties made sure that they had an attorney present, I think that would be significant in making sure that these individuals are also present for coming back to the next court date as well. But I think the biggest significant thing that I've noticed is a lot what Caitlin talked about, some of the risk factors, some of the risks that doesn't take place are the risks of not releasing individuals and the risks of not calculating childcare and transportation issues. Those are certain things that I believe these assessment tools should take into account when we're making these types of inquiries of individuals. I think that could be make a significant change. Because at the end of the day, what we want to do is we want to make sure we're maximizing folks' freedom. Making sure they come back to court at the same time we're maximizing public safety. And if we're contributing to public safety being much more hindered by keeping people and making their life circumstances much worse, we've done a complete disservice to that. So one of my biggest recommendations, I think, is making sure we have a public defense attorney and looking at what additional factors that we need to look at. And I'm sure Caitlin, Sonia, and our other speaker from Durham can recommend additional factors that maybe we could look at, or we should look at. I don't have any of y'all's PowerPoints. It might be somewhere in the emails for Caitlin's, but I would appreciate the PowerPoints from everyone.
Yeah, and I would, and maybe most people here know this, the Attorney General's office, we were having statewide roundtables last year. I think the very last roundtable, COVID may have shelved that, but one of the purposes of that, we were going all over the state. Most of the people you heard from today presented at those roundtables, so that counties, districts that don't have pretrial release, or they don't have the resources some of the other counties have, they came to these roundtables, the different folks presented, and then we had breakout sessions to talk about it. So there's been a movement to get this as more of a statewide effort, but I think it really comes down to counties finding some resources. I just tell you, it's so critical to have an office like Caitlin's office. So there's a central point that we can all go to. I worry her to death. My staff worries her to death, but we know we can go to her and we can get something done. And it's a game changer. I'm telling you that.
I have go ahead, please, sir.
Just going to chime in for 1 second, Ronnie. Thanks. We have done a lot of these working sessions across the state and have learned a lot. And so Jasmine can give you all a list of a lot of the ideas we've generated in response to meeting with these amazing people who are doing this work in the counties that were mentioned. But Jessie Smith has done a pilot project with Judge Brad Letts in Jackson and I think Swain counties, I can't remember exactly, where they don't have the resources to have, what Mecklenburg and Orange and New Hanover have, but they have managed through policy changes, even in small, rural, remote, low wealth counties, to improve their pretrial services so that they are detaining fewer people. And so as you all wrestle with these issues, you can think about what are things that some of the top 20 biggest counties could do, but then what are the things that the bottom 80 counties could do? And they may not be exactly the same. And then there are things that the state can do. Look at the list of misdemeanors. Maybe there are some misdemeanors y'all should just, as a matter of policy, say shall not have any pretrial detention. just draw a line in the sand, no bail. So just some thoughts based on the work that we've been doing. And like I said, Jasmine's done a ton of work and thinking on this issue.
I'm completely on board with Attorney General Stein's recommendation there. Well, we need to look at specific types of charges. But real quick, Sonia, can you tell me, as far as my clients that I've had in Mecklenburg, as far as reminders, a number of them told me that they've received letters in the mail that tell them about their court date. I know they can sign up for text messages. Are there any other type of reminders that we send out to defendants in Mecklenburg?
So for those that are on pretrial supervision, so yes, so we do work with them to get them signed up for the state's text notification system. They do receive letters, from our office with just those reminders, but they also receive phone calls from members of our pretrial staff just to remind them, like, hey, you've got a court date, coming up. And so, I mean, yeah, there are a variety of different options and stuff that are available for folks so that we make sure we're maintaining that communication and make sure that they know what their court dates are.
Do you have any recommendations in your experience for individuals who might not have access to stable housing and a telephone, for example, what you all have been able to do to work with those individuals?
So within the CJS, within our criminal justice services department, I mean, housing is that's a huge issue just for anybody, well, in Mecklenburg, I mean, it's a big topic, in general. But when you couple that with, with folks that have justice involvement, I mean, housing is definitely just difficult to secure. So, with support that actually we've been able to receive from both the state and then also with the county, we started really sort of developing a housing model through our reentry services department, or reentry services unit within our department. And so, because what we're finding is a lot of folks that have criminal histories, they're not eligible for a lot of federally subsidized housing. Their criminal histories also exclude them from just being able to sort of enter into just the general rental market. So one of the things that we have been able to do is really sort of develop sort of this housing model where we're working with really private landlords and private property owners within Charlotte. We spend time really kind of getting out there, talking to them about, who we are, what we do, and who our clients are. And through those relationships, we have been able to really kind of set up vendor contracts and vendor relationships with these private property owners. And so right now we have contracts and agreements and have roughly 20, we call them, CJS houses, across the city of Charlotte. And so when we have folks that are coming into CJS, and again, we started this with reentry and with those folks that are coming out of prison, but we've been able to expand, with some additional support. So anybody who's coming in for a service in CJS, so whether that's pretrial, reentry, whether it's recovery court, treatment court, if they're coming in for other service, so, with some of our jail diversion programming and maybe homeless, we make that available to them. And so we have this model where we can work to get them connected. And we're actually able to cover, some of their rent for up to the first 5 months. And while they're there, we're working with them to really kind of get them transitioned into permanent housing, getting a job. And so those other things that, that they need. And so I think, within a lot of our operations, like I said, with pretrial, there are certain things that we're looking for up front. The needs piece, those are the things that we're working on once they come to us on pretrial. So we have a variety of different things in place, but the housing, that's been really, it's a big challenge, but we've had some success with what we've been doing so far.
Great, thank you.
Ronnie, you had a question?
Yes, jail coordinators, how, do we have those pretty much across the state, or there's certain counties, that look to see why you're there and why individual in jail, and what are some of the issues that concerning the reason why they're there? Just the term jail coordinators, how often do we have those people throughout the state in most of the counties, or there's something unusual? Jail coordinators.
Oh, our person is not called a jail coordinator, it's a population control manager.
Okay.
And we've had one in Durham County for quite some time, so I can't speak on other counties, but she definitely takes a look at the people that are in custody and why, and coordinates transfer to other counties if they're not supposed to be here or they're not being held for Durham County charges. She's in contact with the public defender's office and the DA's office regarding release to address people that have those lower level bonds. And one of the things that I didn't mention was that we also do low bond meetings. So for the people that have those lower bonds that were still in custody after first appearance that weren't able to make the bond, she also identifies those, and we address those individually to see whether or not those individuals can be released either under supervision or just released in general.
As well as community advocate groups and the court watchers. Is that just common for most of the larger counties, not maybe the smaller counties?
Yeah, Mr. Smith, back to your original question about the jail navigators or positions, I'd say there may be 5 or 6 specific positions around the state, but it doesn't have to be. It can be your pretrial program. It can be your district attorney and public defender just getting together and looking at the jail list every week. So there's a lot of ways to do it without a formal position. I mean, all of the detention centers create a custody list. Those can be reviewed by the stakeholders, by the judges. And it's an important piece, I think, of making sure that people are not, and that's why a dashboard is great, because you can see all of those cases and who's in your jail. As to the court watchers, that started here about a year or 2 ago out of a faith-based group out of Binkley Baptist Church, and the NAACP branch, I think, also supported it. So it's really something that I think is happening in more and more places, and is a way for the community to sort of not only understand what's going on in court, but I think influence change. There's nothing like being watched by a bunch of voters to make a judge think maybe more carefully at first appearances about the decision that they're going to make. So it really, I think it has influenced things here, and it's an easy thing for a community to do.
And thank you for sharing that, because that won't cost monies, resources. Thank you so much for giving me that information. Thank you.
All right. We're getting to that time, so I wanted to turn this back over to Representative Maury and for next steps.
Thank you. And Christy, Sonia, Kate, y'all were fabulous. A great discussion. And what I'm thinking is, and correct me, Natalia or Jasmine or Karen, Ellen, we have a meeting next Wednesday going back to our 4 to 5:30, our regular time. Is that good for everyone? On the 16th from 4 to 5:30. That's our regularly scheduled time. Hope that's all right.
Yeah, that's one I probably can't make it next week regardless. I have something going on that's just a priority. So I'll try to make it if I can, but if I'm not on the meeting, you'll know why.
Okay.
Works for me, Representative Moore.
And Commissioner Smith, that okay for you? Great. And Tara?
Yep, works for me.
You're talking way too much, Tara. Okay, great. Well, we'll do that. And I think we'll continue this discussion, maybe talk to Jessie Smith, get some of the broader pictures. And if you'll be thinking about recommendations, and Jasmine, maybe you would present to us too, especially the Attorney General's information.
Sure, I'd be happy to do that.
Thank you.
And we do have someone coming from New Jersey too, to give us a brief overview to kind of provide the perspective of another jurisdiction's approach.
Thank you, Natalia. That'll be great. New Jersey did a huge, I think, statutory bail reform. And so I think that will be good to hear how a state did it statewide. So there is more uniformity, and it's not county by county, a hodgepodge. Just briefly, on September 30th would be our next, we would be looking at juvenile justice issues. And I'm wondering if we have time next week. Natalia was working on perfecting some of our recommendations that we made to the task force at the last meeting. Natalia, do you think we could look at those recommendations on the overcharging and overcriminalization and those other recommendations we made?
Yeah, definitely. And I'll try to get a draft out to everybody as soon as possible, so you have a few days to review those.
Sounds great. It is 12:01. We are over our time. Any last comments, anything?
Yeah, real quickly, I want to make one comment on one of the recommendations we did about charging decisions. I've actually got some folks helping me trying to take the ABA standards, Washington State, and some other things, and turning it into a more comprehensive document that would relate directly to North Carolina and our statutory scheme. So I'm going to try to have that ready in the next couple of weeks. I just think it would probably be very helpful.
Terrific. Thanks, Jim. Appreciate it. Okay, it's Friday. That's it. Hope you have a great weekend. We'll see you next week on the 16th at 4 o'clock.
Thank you.
Thank you.
Thank you.
Thank you.